I am Priya Mishra and I welcome you to this week's Immigration Show. First in the show, we'll give you the visa bulletin for August 2011. After that, Mr. Suresh Dalal will answer your questions. As you know, Mr. Dalal is a member of New Jersey Bar and has been practicing in our state for over 30 years. Welcome, Mr. Dalal.
Thank you.
Please give us a visa bulletin.
First I talked about the family category, then I talked about the employment category. First category is the citizen children over 21, is May 1st, 2004. There is no movement at all. F2A category is the permanent resident children under 21, is 22nd July 2008, it's moved about 3 months. F2A category is permanent resident children over 21 and who has a priority date of July 1st, 2003, that is current. There is no movement at all. F3 category is the married children of citizens, it's 22nd August 2001, it has moved 1.5 months. And F2 category is brother and citizen, brother and sister. It is 8th April 2000, it's moved about 1 month. Now employment category. First category, man of exceptional ability is current. And second category, who is master in the PhD and who has got a priority date of 15th April 2007, that is current. Third category is a skilled worker category. Is June 1, 2002, is moved about 1 month. And other worker category, that is the unskilled worker category, is June 2002, it is moved also 1 month. All other categories are current.
Great. Any news happening with immigration?
No.
No news?
No.
Okay, then let's get started with our letters for today.
Yes.
Our first letter is from Mr. Puneet Singh. He says, my heartiest congratulations for your wonderful and very successful show every Sunday. It is so full of knowledge and helps a lot of people in need. Let me thank you in advance for my query. I have asked this question to at least 10 attorneys and not satisfied with any of their answers because none of them are 100% sure. Which is not good enough for me. I hope and pray that you will be able to answer my concern to the best of your knowledge. I am a Canadian citizen since November 1999. I used to visit USA now and then, visiting my friends, and I used to live in USA before as well. Once when I was entering USA by road, I was stopped and refused entry, stating I was not allowed to enter USA as I had applied for asylum and had failed to appear before the judge. The reason I failed is because my attorney had disappeared on me and I had no idea I had a court date. Now they put a 10-year bar on me and the bar finished November 2009. My question to you, sir, is that if I'm allowed to visit USA freely now or do I still need to apply for a waiver? As few attorneys say that after 10 years you have completed your bar time and you do not need to apply for a waiver, and some say you do. Since November 2009, I have visited USA twice via road, but with the fear of consequence since some attorney told me that I should not be doing that. I was lucky enough and all went well, but this is still because they did not put my immigration information in the system. I cannot fly to USA since when you fly, they scan your passport. I want to visit India in August 2011 and want to fly back to New York. Presently, I am in USA. I have a valid social security number and a bank account in USA. As I was in US since 1989, but could not be legal here, so I applied for Canadian immigration. Am I allowed to stay here as a Canadian citizen, or will I be in trouble if they catch me? Would you please advise me if it is okay to travel to India by air, or I still need to apply for a waiver as I have overstayed in USA and was barred for 10 years? If yes, what is the way to apply for waiver? I was refused entry from the Buffalo border. What is the process to do so? And what forms and where to mail them? How much will it cost? I'm unemployed right now. If possible, please address my questions as soon as possible. This is another point that he brings up. I am single right now. If I marry a US citizen or a green card holder, can I be legal in USA? If so, should I get married in Canada or USA to avoid any complications? In filing my case for USA, I honestly want to move back to USA. Please advise me what is the best way.
I don't know why 10 attorneys. I don't know whom he selected 10 attorneys. This is I don't know, because I'm practicing for 35 years. This is not a unique question. Nothing requires a lot of research. Anybody who is deported from United States, one way or other, because without his fault, he has to apply for a re-entry in this country. And he needs the permission of Attorney General. He will allow you to come in this country. Now, when you apply for re-entry permit, now in your case, which I'm looking up, from every angle, I think you must have lived in the United States for a very long time for illegally.
Almost 10 years.
About 10 years. And then you applied for asylum. And you had no idea that there was a date in the court and you never appeared. So you committed two offenses at that time. You committed an offense of overstaying more than 1 year illegally. That may trigger a bar for 10 years. And then not appearing at the asylum, then maybe trigger another bar. I don't know, say that both the bars should mix together. So maybe a 10-year bar. Now when you apply to the Attorney General, you have to apply, when you apply that one to the consulate. Suppose you are living in Canada, in Toronto, you go to the Canada consulate and file your application for a visitor visa. And at that time ask for a waiver. And the consulate can't adjudicate that waiver. You will mail that waiver where you have been, the order for deportation was issued. Suppose it was issued in Newark, it will go to the district director. Now waiver is a discretionary. It's not they don't grant everybody. They will see your pros and cons. How much equity you have. They will balance how much wrong you have done and how much good you are doing now. You have to prove that you are rehabilitated, you have not committed any crime. You don't mention that you made two illegal entry because you committed further two crimes. And after considering both the points, balancing it against each other. And if your scale of a good deeds is up, they will grant you the waiver. So this required to be done by a skillful attorney in order to get you. Generally, waiver for a visit won't be granted, in my opinion. Suppose you marry an American citizen and file a visa petition. At that time when you go and pick up the visa in Canada, I think you should marry in Canada. File a petition, your wife will file a petition in the United States. And when you pick up a visa, at that time you file a waiver, there are better chances the waiver will be granted. So these are the questions. And I know one time, I'm thinking very much, very seriously. Either these all lawyers, they are practicing immigration law, whether they are knowledgeable, no. This is a very simple, it's not a complicated. I know the complicated cases are, which I have to scratch my head to think about an answer. But is a very common waiver. Everybody who is deported from this country has to file 212. There is an application, we call it Form 212.
Form 212.
I-212. The fees is, I don't know, maybe 450 or something to be paid. But this is a scenario, any good attorney who is practicing immigration law, who has done thousands of cases. There are good lawyers, I don't say there are very good lawyers in Buffalo. Calcutt is a very good law firm. If you go to a right attorney, he will advise you. Find out.
Would you recommend him to get married to a US green card holder or
Citizen.
Citizen? Has to be a citizen.
In order to get a waiver. Waiver chances are becoming better because you are a citizen wife.
Okay.
And if you want to visit, probably waiver may not be granted. These are, all depend upon consulate officer. Every consulate office are different way dealing with the applications. Take an example in India. I think all the waiver application goes to Bangkok, and hardly out of 100 they may grant one waiver. After immigration has become so strict in last 10 years that we have to use the waiver in many cases. People have given a false documentation.
Right.
People try to enter illegally. All of the waivers are required. And that requires a lot of work to be done to put up a good, arguable waiver application. Some people try to smuggle their own family members. There is not a waiver, there's so many waivers available.
Right.
So you need a right kind of waiver to be selected. A good affidavit to be filed. All the documentations will be sent. How much, what are you doing in Canada, whether you've done any social service, you've not committed any crime. All information should be provided. Because this type of waiver, 212 waiver, to get the admission in the United States requires no relative.
Right.
You can do it on your own. If you marry, that add more to your weight, to your good deed. Because to marry a citizen and to be a unit of your family, they may be considered more favorably.
Well, we have another waiver question, so we'll hold that thought. We'll take a short break. We'll be right back after these messages. Welcome back. You're watching the Immigration Show on TV Asia. Like I said, we had another letter regarding waiver as well. It's from Mr. Patel. He says, I'm doing business of convenience store with gas station having 8 to 10 employees respectively. Always watch your program on TV Asia on Dish Network. Immigration history is I came to here on L1A visa along with my wife and 2 kids. Had a L2 visa on July 5th, 2011. My visa expired on November 2011. Before that, I filed for extension for L1A for all of us, which was later denied. Then I filed appeal for that, and simultaneously I filed I-140, 485, 765, 131 for all of us, which are all denied, saying your activity is less than a year and your executive position not approved, along with some other reasons. Then I filed appeal for I-140 as on time. Meanwhile, I consulted another lawyer. As their advice, I filed new I-140, 485, 765, and 131. In response to that, we all received our EAD cards and travel documents, which has expiry date of September 2011. My earlier appeal for I-140 meanwhile denied, and sometime later I got a RFE for new I-140, which we replied, and later it was also denied. After 2 months, my I-485 was also denied. In response to that, I filed appeal for I-140 and 485 on time. Meanwhile, I applied extension for EADs in April 2011, which is also denied in July 2011, saying that the filing of a motion does not make the 485 pending unless USCIS has granted the motion and USCIS has reopened the 485. Meanwhile, I consulted one more lawyer. He studied my whole case and advised me to file H-1B, which I filed in May 2011, which I got RFE and we responded to it. Now waiting for a positive reply on H-1B, as he advised me if H-1B approval, then I have to go to India to Mumbai consulate for visa, and they will definitely deny my visa. Then I filed for the waiver. My attorney said he knows the reality in Mumbai consulate, but has confidence in my waiver being approved. My questions are, can it be possible to get waiver, because I know I got barred for 10 years, so what are the chances of getting it? I'm also waiting for positive reply for appeal or to the I-140. What do you think? Do I have any chance of success? Is there any hope for immigration reform bill by US President? If it is present in Senate, I like to wait for it before I quit US.
My advice is not to go to India.
Not to go.
No. Waiver. It's another question, very important. I don't know. Listen to me. I don't know what type of attorney they are consulting anymore nowadays. I'm losing a faith now, okay, in my profession. Waiver can be only granted, you must have a qualified relative.
For this kind of thing?
Yes. What type of waiver you are seeking? You are seeking 10 years bar waiver because you overstayed in this country.
Right.
10 years bar waiver is a very, very difficult to get. And you have to put unusual and extreme hardship, not to you, to your qualified relative. Your wife, your children are all illegal in this country because they are all selling the same boat, And who is going to file a waiver for who? Is your father, mother living in this country? Are they qualified relative? Are they going to suffer a hardship because you are deported from here? This waiver is very, very difficult to succeed. I'm going to take about 10 years waiver. I tell you one thing, and there is the same thing. They are selling the same boat when you file a false and fraudulent document. I got a guy, which I told last time. He came here with his family. He was very impatient. He was not making money in India, and he thought he can start doing better. He can build up a better life here. And his mother is here, poor woman, came here in this country for 22 years ago and left his young son at the age of 13 in India because every burden was on her shoulder to work, because the family is completely finished, devastated, and the husband was very depressed because he lost a lot of money in the business and he couldn't recover. So the woman has no alternative. Sometimes, they said, the real Indian women sometimes are really strong, stronger than men. So she came here, not educated very much. She never thought that she would pull up the family with the income which she would make in India. The only profession left was housekeeping. She was very lucky. She secured a job with a very rich Indian family in the United States. And they turned out to be very kind. So she worked faithfully with them for 22 years. She is now aging. And she's aging, and she thought her son would come here if the poor guy was waited in line for 1 or 2 years more. She got a green card. She became a citizen. And she was saving a lot of money because she was living free of charge. She had been provided a good home. She was cooking food there. She's a cook, so she doesn't have to worry about food. So shelter was there, everything was there, everything was at her service. And they treated her well as a member of the family. That woman came to me because his son tried to sneak into this country on a false documentation. And he was caught ultimately here and he was deported. Now we have to seek a waiver for presentation and for document. And I put this story now in waiver application to see why the family should not be united. Hardship, because she is struggling. I don't know whether the waiver would be allowed, but I found out another point, whether there was any fraud on his part, and that I won't discuss. So the waiver is a very, very difficult issue. And in order to secure a waiver, you need a qualified relative. Now you come in this country, L1, all denied. How the consulate is going to look at that application? Says, sir, you want to stay in the United States at any cost. We are not going to give you any. Forget about the waiver. We are not going to stamp your passport. You stay here now. So who advised you? This type of that you can go and there will be a good chance of getting a waiver, and waiver on what basis? We call it a 601 waiver.
Right.
And that waiver requires extreme and unusual hardship. And I told you earlier that waiver out of 200 cases, one waiver is only allowed. And in a very rare cases, waiver is allowed.
Alright, with that, let's take a short break. We'll be right back after these messages. Welcome back. You're watching the Immigration Show on TV Asia. Our next letter is from Mr. Garg. He says, please tell me the latest current priority date up to which an employee on H-1B visa holder can apply for green card. Now, I don't understand his question really.
There is no question of priority. First you have to file, get H-1B, get a labor certification approved, find out whether you are going to be a master or you are in a third category. Then after labor certification is approved, then you file and then wait in the line.
That's when the priority date comes.
Then the priority comes only when the date of labor application is approved. and I-140 is filed. And you know which either you are in a skilled worker category or you are got a master or PhD, always depend upon it. In everything is waiting, a third category, skilled worker category, your 2 years experience waiting is more than 15 years. And if you are master and PhD, waiting is about 5 to 6 years.
Right. And I guess if I look into this one line question, when can a H-1B holder apply for green card? Is another question that comes to my mind.
They
Is
cannot-
there any
There is no direct. The only people who can apply directly for a green card is intra-company transfer.
No, but the employer can apply for their green card if you're on H1,
Then the employer has to file a labor certification for you.
right? But
You know,
is there a certain amount of time that you have to wait before you
No.
can file for the green
No,
card?
no. You can apply for H-1B application, and immediately that's granted. You can file simultaneously labor
The labor
certification.
certification.
You don't have to wait.
All
You
right.
must be in status in order to file,
Naturally.
and you have to remain in status.
Mhm.
Yes.
Alright, so Mr. Kirk, I hope this answers your question. If not, then please write back to us in more detail and we'll try to help you out. Our next letter is from Ishwarlal K. Mistry. He says, I and my wife arrived in USA and stayed as under. 1. Arrived on 12th July 2005, stayed up to 25th July 2006, fly on 26th, 1 year and 14 days. Arrived again on 4th June 2007 after medical treatment of my wife in India and stayed up to 12th September 2010. 3 years, 3 months, 7 days. Left on September 12th for medical treatment. Arrived again on 12th December 2010 after medical treatment for 3 months. From that 12th December 2010 to date, we are in USA with the following address. They live in Augusta, Georgia. And he wants to know when he can apply for citizenship.
My question is there any time they stayed more than 6 months out of the United States?
July 26th, they left and they came back on 4th of June 2007. So that's more than 6 months.
More than 6 months. Now the question is, when you are more than 6 months, the burden is on you to prove that there was a reason you have to stay out. If you have the medical certification and if you can prove that at that time you cannot afford the medical treatment in the United States, so you have to go out and therefore you stayed, then you have to prove that you never worked in the United States and never worked in India during that time. You have enough money, and then you have to prove that you have a strong tie to this country. Means you are filing taxes here, you have an investment here, something. The reason was very simple, that once you are out of more than 6 months, you lose your domicile here. And then you have to prove that you have never forsaken your domicile in the United States and you have every reason to come back. So all these documents should be prepared in advance before you go. I have done cases where my client not one time, 2 times were absent more than 6 months. But she was fighting a litigation in India and every time she has to stay there. But she used to go, she was a old lady, more than 65. She had a prescription, list of prescription which we are getting for last 5 years. We see as a bank account here. She has all the relative in this country. We prepare everything. Then we were successful in getting the citizenship. So anybody who files your citizenship application is he has to provide all the documentation to the immigration department. Generally, the law is very clear that in last 5 years you have to stay more than 2.5 years in this country. Anytime you can't stay more than 6 months out. If there is a one time you said 6 months out, probably it can be excused, but provided you have very strong evidence that all these documents are to be done.
Now, since September, they have stayed here. Since 2007, they came here. They stayed 3 months, 3 years and 3 months, and then they were only gone for about 3 months. So, from June 2007, they can count the time as
So
continuous stay.
I tell you, they have completed 5 years.
Right,
There is no problem.
right,
They have more than 2.5 years there in this country.
right.
The only problem is they were 6 months out. That's the only problem.
That's the only
That's
thing,
the only
yeah.
problem. So they can file the application, but they prepare all the documentation.
Okay. Alright.
And if the documents are properly done, it's done through an attorney. If you can't do it, then you will get it.
Okay, Mr. Mistry, I hope that answers your question. And it brings us to an end to our show. Before we end, here's a quick look at the priority dates for August once again.